Welcome. Hi, this is Carol from Skill Check. Today we're going to talk about non-tenant payments and their people's rights in self-storage. Um, this came from a question from one of our listeners. So I do like to talk about these sorts of things because it's really important when you're getting ready to take payments. Who can you take a payment from and how does this go? So that's what we're going to be talking about. Well, first, to answer, who can pay on a unit, the answer is anyone can pay on a customer storage space. However, the problem is if they pay in something other than cash or check, other than cash, let's just start with other than cash, then there may be a dispute. And this especially happens with credit cards. So when you have a dispute with a credit card, if the person is not a tenant at the storage property, they easily, every time it seems like it's ever happened to me, that they've said, sorry, you didn't have anything saying that they were paying for someone else. So I thought, okay, if they typically, look at stuff like this, and if they don't have storage, then hey, how do we figure this out? And we don't without losing out on the payments. So I came up with a form that it's a non-tenant credit card authorization form. So you need to be prepared and have something like this. And if you need something like this, you can certainly get it from us, or you can also just put it in your software and use this as a guide. But be prepared because you can allow a non-tenant and just to show proof to the credit card company that yes, this person did know that they were paying for this other tenant and here's their signature. And every time I've ever shown this, it has worked with the credit card companies. So that's a real plus for us. So when you think about this, there are other kind of questions that come up about the rental agreement and, spouses and how we have a husband and wife showing on the rental agreement because some storage companies say you can only have one person on the contract. Well, the problem with that is that the husband and wife, they have a right to be on a contract together. So because it's both of their stuff, and I don't know why you wouldn't do that. Because if something happens to one, you'll have the other one that can get in without any kind of trouble. So they both have the right to be on the contract. So either one can contract. So let's just say the husband's there and he puts the name, Carol and Tom. I've had lots of Toms, so whatever it is. But you can both contract like that. So you can also put an and or between the name. Now, in the common usage for or denotes exclusive alternatives. So it means either the husband or the wife can be there and do that. And if you have an and, it says that both parties will need to be there. Like if you would buy a house, you would make sure it said and on it because you would want to make sure they couldn't sell the property without, the husband or the wife, being party to it. So these elements need to be there. So when you're thinking about this, and I'm going to say the best thing to do is put, the and and it's going to be, it depends on whether how serious you are, I guess, or how serious the people are about having to both be there. And maybe you can just explain it that. Or means either one of you could close the thing out, pay on it, whatever it is, which we allow anyone to pay on it. So pretty much. So make that and or understandable. If it's and, they both have to be there. If it's or, either one can close it out and or do whatever with it, downsize it, whatever they're looking to do. There are also times when, let's just say that didn't work or something happened with that issue. A person says, well, I'm the mom and I put it in my name, but it's really my daughter's. So I would like to now assign that to her because she's of age or something like that. And I have had where the son was in prison or the father wanted to take, over the payments of that, or it was put in a moving company's name, yet the goods belong to the customer. And they showed us proof that the moving company was out of business and they had bankruptcy, and so we allowed them to take it over. And we did an assignment of a rental agreement and then had them sign a new agreement. But so you could allow a current customer to sign this over to another person. Again, something like a former husband or wife, a family member, boyfriend, girlfriend issue. So it's really the boyfriend stuff, but the girlfriend rented it. I mean, it gets kind of complicated sometimes. So if you're not sure, you could always ask your supervisor, but you want to make sure that you're doing this correctly and the way that your company wants it done. But you can use this form, assignment of rental agreement, to someone else, and it's certainly doable. But even if I use this, I still get a new signed rental agreement from that other person, but I attach this to it, that we're showing that it went from someone else to this person. And another question that's come up is, customers giving the keys and codes to someone else. Well, if the customer, if it depends on, your rental agreement, but here's something from mine. Should occupant appoint another person or organization to enter the storage space? And I'm going to say organization might be FedEx or, something like that. If you have drop-offs, I mean, that kind of organization might be able to get a key and open it up. UPS, the same type of things that they're dropping it off. And then anymore, it would be Amazon trucks, at least at my house. So the owner shall assume that the possession of the key and the code is evidence of the authority to enter the occupant space. All information provided by the occupant on the lease is confidential and will not knowingly be disclosed to anyone without occupant's prior consent, except for law enforcement purposes. So that's a nice, good thing to have in your rental agreement. And you need to see what your conduct says, or it might be a different heading. But again, it's talking about the key and the gate code as evidence of being able to come in. And sometimes I've had people that have come in, for example, they've had death of a tenant. And it's interesting because the problem is, sometimes the person on there, uh, well, the person coming in has the key, and yet they're nowhere anywhere on the contract. So there are forms for this. Let's say, someone passed away. There are small state affidavits. And I just, I just put several here, the Pennsylvania, Idaho, there's several that are like this. This one in particular is from California. But they are affidavits like a personal collections form. It just depends on they kind of have different names, but they're all affidavits of successors, basically, as they call it in Washington. Now, when you get one of these forms, it's filled out already, and you can give it to the customer if you say, oh, if there's an issue, here's a form. And this, I know it's in our forms book that we have at SkillCheck. But if for state specific, you may just want to go to your specific state and find this. But this is a really good example of what you might find. And then they get this all filled out, and basically it's coming from the state, and you can go ahead and allow that person to enter the unit, or give them, open it for them if they don't have the keys, something like that. Now, all of those things, I would say probably a good idea to talk to your supervisor. I gave you also a sample one here from Arizona, and it's a 3 pages of it, but again, the information that's there, the person who died, the date of that they died, and this is such a common question in self-storage, so I thought at least we could bring it up and tell you what you can find out, and give to the customer, and tell them that they will need that kind of affidavit, and look it up for your state. It's easy to Google and to get to. Now, the last but not least, I want to tell you about my favorite attorney in self-storage, Scott Zucker. And I didn't get his name on here. How did that happen? So Scott, you can find him and call him directly. His number's here, his fax number if you want to fax him something. But his email is here also. I think the interesting thing, if you're not sure about what to do and it's really complex and complicated in a way which you're like, well, something's not right here, get some legal advice. It doesn't hurt. It's not that expensive. And ask, what is it going to be, to talk to you or help us with this problem. And especially when you're talking about a unit that you want to free up and to get back on the market. And especially if there are those some of those large units that you think, wow, if we let this sit here, and sometimes I've seen it, 3 or 4 years it's left. And I'm like, why would you do that? You've got to, get on it. Especially if someone just passed away recently, get to this and help the customer get the right forms to get to you. And if you need help, Scott is certainly a perfect one to go to get that. Well, thank you so much for listening to this quick little webinar. Again, my name is Carol Mixon, and if you have any suggestions for topics you'd like, please let us know. We'd be happy to help you. And subscribe to our channel. That really helps too. I know we don't get many hits on my reviews. My son's like, oh my God, Mom, you're not even in a range of any popular place. On YouTube, I'm like, oh, well, it's still storage. So I'm just doing our best. So any ideas for suggestions for webinars, let us know. Thanks and happy renting.